Hi, I'm Joshua Harris, a licensed insolvency trustee in Toronto, Canada. And for this week's trustee tip, I'm going to talk to you about student loans in insolvency. People often ask me, can I get rid of my student loans if I do a consumer proposal or a bankruptcy? It's a fairly complicated answer, but I'm going to do my very best to simplify it for you. First and foremost, you can get rid of a student loan in a bankruptcy or a consumer proposal if you've been out of school, whether you dropped out or you graduated, for at least 7 years. So 7 years has passed. If less than 7 years has passed, that student loan will survive your consumer proposal or bankruptcy. However, a portion of your consumer proposal or bankruptcy payment will go to that student loan to reduce the amount owing. Keep in mind, however, if your student loan is in a scenario where it will survive the proposal or bankruptcy, interest will continue to incur. And so it's important that you do apply for interest relief if you want that interest relief during the consumer proposal or bankruptcy period. Now, there's a couple different scenarios. What if you have hardship? Maybe you are ill or you're unable to pay your bills. There's a special provision in the law that says that if you've been out of school, whether it's from dropping out or graduating for a minimum of 5 years, and you've already filed a consumer proposal or a bankruptcy, with a court order, you can prove that you suffered from hardship and your student loan will go away, reducing the 7-year period to a 5-year period. Now, this can be a very rare occurrence, and it also requires a lawyer, so make sure to talk to your trustee about that option before considering it a reality. Another question I often get is, what happens if I went to school, and let's say I graduated or dropped out 10 years ago, and then I went back to school 3 or 4 or 5 years ago, and I got OSAP, or even I paid for my own education the second time around? What happens to the initial OSAP or student loan from 10 years ago? Well, the answer is actually very interesting. There is case law in Ontario that says you can get rid of that original student loan. So there is a multi-date system, meaning the portion that is more than 7 years old does go away in the bankruptcy or proposal, and the portion that is less than 7 years old will not. And if you paid for your education the second time around, it's the same thing. That original student loan from more than 7 years ago will go away, whereas the new education is fine. So keep in mind that that 7-year rule is somewhat flexible. It's not exact, and you should certainly talk to your trustee about how that will affect you or your family if you are or are going to file a consumer proposal or a bankruptcy, or just want some general financial advice. Remember, student loans are there to help you, not to hurt you. And we as trustees are there to give you the advice that will continue to help you and not hurt you. Give us a call if you have any questions or concerns, and don't forget to like and subscribe to get more weekly trustee tips. Thanks.